you said there was an evidentiary issue, Mr. Jimway?
Yes, Your Honor. Yesterday, after the court had concluded, I arranged for Mr. Albee to have an opportunity to interview the state's forensic computer analyst, one of them, Marty Cook. And at that time, I had recalled that there had been some evidence that Marty Cook could have been testifying to, and I think the court had a number of months ago suppressed this evidence, but then that was at the same time that you'd suppressed the evidence regarding the entries regarding the defendant's interview with Kelly Labonte. The evidence that I intend to ask Mr. Cook about, and I wasn't going to introduce any of the evidence, pertains to 2,800 photos that were on the defendant's work computer that was seized in 2002 at the time of the defendant's arrest.
Let me try to make it short.
These are 2,800 photos of penises.
Let me try to make it short so I'm going to understand the issue from the very beginning. Is he able to date when the photos were downloaded onto that computer?
No. We just know that they were, at least I don't think he is. We know that they were on the computer. They were Mark Jensen's work computer. There are 2,800 photos of penises organized according to size.
The judge, in response to the court's question, I don't think there's any dispute that it's after Julie Jensen's death. You could say that. I don't think there's anything on that computer that predates 2000 or something like that. That's just for the court's information. I have a number of objections.
Well, Your Honor, if you'll remember, there was a conversation between Mark Jensen and Dave Nearing on some Friday afternoon after Julie's death. And Mark Jensen was complaining to Dave Nearing about how he wanted his home computer back and the police were sitting on it. And Mr. Nearing had expressed the opinion, well, gee, it's a good thing they didn't take your work computer. And then Monday morning, Mr. Jensen told Mr. Nearing, oh, gee, the hard drive is fried on the work computer. So we have reason to believe that the work computer that was seized in 2002 doesn't contain anything that was on the computer in 1998. But that doesn't really matter with respect to this particular issue. As the court has previously noted, this is an interest of the defendants that predates 1998 and postdates 1998, and the fact that he was still fascinated with this in 2002 is further evidence of the defendant's preoccupation with this particular issue. And the only reason that the state seeks to admit this testimony is that it is relevant on the issue of who was leaving those photographs around the house in the years preceding Julie Jensen's death, particularly since one of those photos had written on it the words, "Is his as big as mine?" And once again, these are photos where many of them include yardsticks and rulers as a means to measure the object of interest.
Judge, from my recollection of looking at that CD, which is some time ago, because it wasn't going to be at issue in this trial, and there has been no notice until yesterday, there are a lot of pornographic photos on that disc from the work computer sometime after 2000 is my recollection. When I had looked at it, I didn't understand the basis for this claim of there being any kind of categorization of the pictures. It's just, there's just lots of pictures on there. And so I don't even think they make that showing. To the extent they do, it's based on information I haven't been provided as to the basis for that opinion. And it's been years since I requested notice of intent to introduce other acts evidence, and this wasn't proffered. And now, as of yesterday, they're trying to forward it. I haven't looked at it. I don't recall it particularly well. I'm not in any position to cross-examine about it. There hasn't been notice. I don't think it's relevant. Again, it's unfair prejudice. It substantially outweighs any minimal probative value it has. And I don't think there's any legitimate purpose under 90404-2. I think this would just add to the due process claim that I have, and I'd make it here that Mr. Jensen's due process right to a fair trial precludes the admission of this evidence. But, I mean, let me just start with the notice claim, and then I'm not prepared on this. In addition, the court should be aware that I will have other concerns about Mr. Cook's testimony. The court may recall that probably in May, I filed motions in this case, and one of them was for specific notice of what experts would testify to. And in particular, I pointed out I didn't know what they would be testifying to on the computer evidence. The response to that motion was, you'll hear it at the forfeiture hearing. That will be your summary of what is going to be introduced through Rhonda Mitchell. And she testified, and then I had a summary, and I had no more complaints about Rhonda Mitchell's testimony. In December 10th, I think, we had a hearing, and I raised the same issue with regard to Marty Cook, and the state said, well, we're going to call him in rebuttal, and if he testifies, it'll be regarding the shadow. And that was pretty much it. I had earlier had conversations, and one reason why I was very concerned about the computer evidence is there are computer disks at least numbered through, I don't know, 37, 38, 39 or something like that. And needless to say, I'm not eager to look through 38 computer disks and try to note any differences or anything else. I was told Rhonda Mitchell had produced 2 computer disks, and I was told that the testimony would be restricted to those disks. I also was uncertain as to whether I had all the disks and whether I needed to obtain them, because if there's going to be testimony, obviously I'd get them. And Mr. Jamboy said he didn't think he had anything like 37 disks, and he'd let me know if they were going to get into some other disks. Now, as of the last 2 days, I've been told that there's an intent to get into a different internet history here through Mr. Cook. There's a PowerPoint on index.dat files, and there's a bunch of new things that I didn't have any notice of. I'm not prepared in the slightest to respond to. It's not just a matter of knowing something about computers or being prepared for a cross-examination, but these disks contain lots of data. I haven't had sufficient opportunity to go through the data, try to decide what I want to do with it, what distinctions I want to draw. My expert is out of the country. I haven't been able to consult with him. And as I said, I asked for notice, I think it was in May on this, and I was told several times as to what the notice consisted of, and that my motion was moot because they had provided it through the forfeiture hearing of Rhonda Mitchell. As to this thing called the shadow, as I understand it, it's sort of a live demonstration of what they believe the computer user was doing on December 2nd and December 3rd. I have concerns there about the appellate record that might be created in this case, because as I understand it, he'll just be flipping through computer screens and it will not be preserved in any way. And
It'll be preserved on the television, no?
Well, I don't think that's sufficient, because from doing appeals, not only the lawyer, but I'm sure the Court of Appeals would not be happy with having cites to some video to look at a screen as opposed to find some document that might be important within.
Well, you know, I have to tell you that I feel that we in the legal community would embarrass ourselves if we refuse to embrace the technology of the 21st century in collecting and preserving evidence, and instead said, well, no, we're not going to accept a video record which is made live and is being made, and say that and say we can't admit this evidence because we haven't accepted this in the past. I mean, that's what gives lawyers a bad name.
That's not what I'm asking.
Maybe I'm misunderstanding what you're saying.
Well, the same problem came up with Rhonda Mitchell in her testimony at the forfeiture hearing. She's going to do a PowerPoint, and they just wanted to go through the PowerPoint without introducing what the PowerPoint slides were. And that's the way to create an appellate record. They were printed off, introduced into the record, and now everybody can see what was looked at on the screen.
Well, tell me why that isn't being accomplished by taking the, I'm watching it right now, 20-second delay or whatever they've got on there. I can look at it right now, what's being broadcast.
I don't think that's an official record that's been accepted by our Court of Appeals. I don't think it's I don't think
you're
it's
not going to tell
sufficient.
me on this, but go ahead with the
I
rest
don't
of your
think it's
argument.
sufficient for citing the record. I certainly wouldn't want to be doing appellate briefs trying to have to watch video and cite that, and I don't think the Court of Appeals is going to want that.
I agree with you that would not be, we wouldn't want, although that seems to be the technology, that seems to be the way they're going, but no.
This is what I was saying.
But you're asking me to suppress the evidence because there has not been developed technology to do it, and I'm saying, what are you talking about? The technology is right in front of my eyes. I'm not going to buy that.
I'm saying there is technology. Print them off in advance. That's the technology.
No, that's not going to, I'm not going, I understand the problem the Court of Appeals would have with it, but I assume that it would ultimately involve watching an audio video record of whatever nature that's going to last whatever length of time the examination lasts. And I understand that wouldn't be good for the whole trial. That would be an awful burden on the Court of Appeals. But when you're talking about a specific exhibit, this becomes the exhibit. But let's not get bogged down on that. Your objection's in the record on that. As far as the shadow, did you have more objection to the shadow?
No.
Okay. Let me say that, first of all, I do think that the evidence that the district attorney is seeking to admit is relevant for the same reason that was discussed yesterday, and that is that you have, to this moment, you are denying, as I've heard and seen in this court, you are denying that the defendant is the source of the persecutory photographs which were being left, according to the testimony, at the Jensen home or at Mr. Jensen's office. And you're denying that. The district attorney is seeking to prove that he is in fact the responsible party, and that is relevant evidence on the subject of motive and malice of the accused, which is directly relevant to his whether or not he desired to bring about her death. And
but I don't understand the connection between photographs on a computer later on, given how much pornography is in the
Colonel
world.
McCormick's commentary and all the others, but Colonel McCormick says the other act's evidence must bear the signature of the accused. Now, that is the historic view of it. It has to have the signature of the accused, which isolates it to one person. I understand that this evidence about the accused would not be as definite as that, but it certainly makes more likely, as I've said, and there's been a lot of discussion about personal sexual practices and modes of excitement. And there are more common ones, and then there are ones which are unique or possessed by a small percentage of the people. And what the district attorney is describing sounds like it's way into the fractional, into the third decimal maybe, in terms of where you'd find that in the general population. I would think maybe I'm. Well,
Your Honor, it certainly is what the defense counsel would describe as an outlier. Somebody
An outlier, yes. But anyway, so I think it's pretty close to being the signature of the accused, or at least signature of, what is the universe of people who would carry on a years-long persecution of either just Mrs. Jensen or these people? How many people who would fall into that universe would also have this peculiar fetish? So I think it's sufficiently close to the signature of the accused that some people would look at it as the signature of the accused. So it is for a valid purpose because the defendant is denying that he participated in this conduct. So the district attorney's got a right to say he's the one who did it,
Well,
or to show that he's the one who did it by linking it to this other evidence. Now, having said that, we're at a point, Mr. Jamboys, that I'm not sure that there's going to be a whole lot of jurors still in doubt about this subject, that a question of whether or not the defendant has...
I would agree with that. But
so
I've got an obligation to-
strikes me as what the objection that Mr. Albee has been often phrasing during this trial, 90402, that, to use the exact words of the statute, it's 90403. Although relevant evidence may be excluded if its probative value is, well...
Your Honor, may I just speak briefly?
Oh, I see that word substantially again. If it says if its probative value is substantially outweighed...
By its unfair.
Well, I don't want to get into the unfair. I don't accept that it's unfair. As I've said before, this is evidence not of deviance, but of kinkiness. And so I don't think it's so damaging to the accused in terms of the jury convicting the man of this very serious crime just because he have a strange sexual practices, as opposed to someone who would be a sexual deviant. And there'd be the risk of an unfair conviction. But it is the needless presentation of cumulative evidence. But it says substantially outweighed by the danger. You know, that substantially outweighed only pertains to the danger of unfair prejudice. It does not pertain to the needless presentation of cumulative evidence. And you just acknowledge that one would think there would be a small number of jurors, if any, who would at this point not have an understanding that the defendant has this fetish?
Now, Your Honor, if I may briefly respond to a number of things, because, and I'm concerned about the appellate record here, because counsel has now recounted a heavily parsed history.
Oh, let me respond to that about his claim of failure of notice. I will tell you that as I recollect the discussion of the evidence you say that, quote, I suppressed, which indeed I did discuss a large volume of evidence that wouldn't be received of this nature, but I thought that pertained to photographs of acts of fellatio taking place. I don't recall any mention, this is news to me, about these measurements and 2,800 photographs.
That's why I want to make this record. Okay?
Go ahead.
Because if the court will recall, there were a number of pretrial hearings in this case back in 2003 and 2004 leading up to the first trial. And at that time, there was an anticipation that we were going to be trying this case in Kenosha County. I had discussed with both Mr. Albee and Mr. Glynn this evidence of 2,800 photographs organized according to penis size. And that's how it is organized. However, Mr. Glynn and Mr. Albee did not want this stated on the record in court for fear that it would then be publicized in the Kenosha News and that it would influence the jury pool, the potential jury pool, against their client. Now, that's why it's important that I make this supplementary record. There's not a shred of doubt. And I believe that Mr. Albee will confirm this, that we had these conversations off the record between Mr. Glynn, Mr. Albee, and myself and Mrs. Karaskevich, where we were talking about these 2,800 photographs that were on the defendant's computer organized according to size of penis. Now, the only issue at that point was whether or not the state was going to be delving into this other act's evidence about leaving these photos around the house, because the evidence is equivocal. At that time, it was even more equivocal about whether it was the defendant or somebody else that was leaving those photos around the house. As we got closer to trial, it became clear to me that we were going to be seeking to introduce that evidence. So the only reason that there was nothing on the record about those 2,800 photos is because defense counsel had specifically requested that we not talk about it on the record for fear that then Ms. Hansen from the Kenosha News is going to do a story about it, and it's going to inflame the jury pool against the defendant, even if the evidence turned out to be inadmissible. Now, so when Mr. Elby tells you, oh, this is a surprise to me, that's pure nonsense. He knows it's not a surprise. He knew about those conversations. It's inconceivable to me that he forgot that conversation, just as it's inconceivable to me that Kelly Labonte forgot the conversation that she had with Mark Jensen.
You have made your point. Did you want to respond?
Yeah.
Go ahead.
Judge, I never made a claim, and so I shouldn't have to defend myself, that there wasn't discussions about these pictures at some prior time. I believe some of those are on the record. We just didn't show them. And Mr. Jamboys is right. There were some things we did
It's news to me.
off the record. But
about 2,800.
well, I think that's on the record. I think that's on the record somewhere. But the problem is I have continually, through this trial for 5 years, asked that I get specific notice of what they intend to use so I know whether we have to argue about it beforehand so I can prepare my trial accordingly. And State versus Fink and the general practice of most courts says you get notice of your other acts evidence, and that's what we asked for, and the court has said. In fact, I know there's a court order in the past saying you give notice of any other acts evidence you intend to introduce. And in this trial, since we've prepared, since this case came back from the Court of Appeals, there's been no notice. And so I didn't take it into consideration.
Of course there wouldn't be notice because it was agreed between the parties so that it not be part of the public record. And I will tell you that I didn't have any discussions with you lawyers that are not on the record.
No, that's not at all. Again, the state wavered as to whether they're going to try to introduce that evidence or not, and ultimately decided they weren't pursuing it. And that's where I've gotten no notice. And if Mr. Jamboys wants to recount some conversations since 2004, that's fine. I'll listen to that. But I recall 0 conversations since this case came back where he said he was going to introduce this or requested a court ruling on it. In fact, we've had a number of hearings at which the subject was what specifically will be permitted in this case.
Well, let's get to the bottom line. How much time do you need to prepare for the evidence about the 2,800 penises organized according to size?
I don't know what the basis is for saying that they're organized by size, because I looked at that disc a long time ago and I don't understand it. What difference does it make? Because
that would make it even kinkier. But I mean,
well, he can ask the witness that on cross-examination. He asked them that last night in the foyer, in the break room, and the witness is prepared to testify. It was organized on folders and organized and entitled "Big," "Bigger," and things like that. And then contained in there were photographs that reflected the title of the file.
We're back to my question to you, which is, why is this necessary? Why isn't it cumulative? And why isn't it going to slow us down?
First of all, I was going to ask Mr. Cook maybe 5 or 6 questions about this. So it's not going to slow us down in that sense, unless defense counsel wants to cross-examine Mr. Cook and his conclusions that they were organized according to size. It's not time-consuming. I'm going to be presenting it in a way that is as non-inflammatory as possible. I'm not going to be producing any of the photographs. I'm not going to ask him to show any of the photographs. I'm just going to ask him what they found, and he's going to describe that. It would take less than 4 minutes for that exchange to occur in the courtroom. And in terms of, let's remember what my burden is. This is a circumstantial case, Your Honor. We don't have any confessions to committing murder in this case. We have a poisoner who worked very, very hard to conceal his tracks. The state has a tough case here. Now, I think we've put a lot of evidence in, but our obligation, Your Honor, is to persuade every single juror beyond a reasonable doubt. I believe the vast majority of the jurors in this case are ready to accept the proposition that it was Mark Jensen that was torturing his wife over the years preceding her death. But I don't know that all of them will. There may be some. There may be 1 or 2. There could be a holdout who's saying, no, I'm not satisfied of that. I want to reach that juror with this evidence because I have the burden to persuade a unanimous jury beyond a reasonable doubt of the defendant's guilt in this case.
Mr. Alvey?
I've made my record in terms of signature that the court was talking about. there's nothing, the photographs that are left behind prior to 1998 are described by Mrs. Jensen of being of her. There aren't pictures of just penises left behind at that time. So there's not this signature that the court is talking about, that there were all these.
He's not talking about any other photographs, he's talking about penis pictures.
Right, but the court is talking about signature, which means that there has to be a match between the signature post-death and the stuff that was left for the harassment, because it's only being used to bolster the harassment issue. And the harassment pictures aren't of that same kind. They supposedly involve Mrs. Jensen. They're not computer generated. There are none of these. The other thing, there's none of these photographs that were supposedly left that Mr. Cosman and Detective Ratsberg saw. There's been no claim that what they saw on the computer later on matched what was left behind. So we don't have a signature. We don't have a signature between what's there in 2002 and what was left behind in the harassment activity.
You're talking about matching of the photographs, and he's talking about matching of the particular modus or practices of the accused with what was done in terms of leaving photographs and with writing on them about commenting on size.
Well, supposedly there was one photograph mentioned by Mr. Cosman that was written on, and of course it's not in evidence. They don't have it. So I mean, that doesn't seem like a modus operandi when we have this happening over a period of years, and Mr. Cosman said it was all sorts of different kinds of sex acts depicting a woman. Julie Jensen thought it was her, and that's why she was so embarrassed by it.
Well, it's a close case. I think I'm going to decline it on the basis of cumulative evidence. I'll tell you this, as I said before, I'm of the belief that the jury should get as much information as possible, and the court's function is to suppress only that which absolutely needs to be suppressed. So it's a very close case, so much so that I would say this, if you want to renew your request, if the defendant takes the stand as to whether or not he may be cross-examined about this material, that I'll leave that in reserve to determine that, depending on how the trial progresses. But I think I'm going to exclude this on the ground that it is unnecessarily cumulative.
Thank you, Your Honor.
All right, anything else before we start?
No, I think we can get started, Your Honor.
All right, ask the jurors to come in, please.